So this question was asked in 2017. Now let's see the question. So it says that which principles among the following was added to the directive principles of state policy by the 42nd constitutional amendment to the constitutions. So this was asked that in by the 42nd Constitutional Amendment Act 1976. Through this act, which of the following were added? So if you see the options, so first is equal pay for equal work for both men and women. This was in the original constitutions, and this was dealt by the Article 39 clause D. So this was not the answer. This is not our answer. So if you see the next option, that participation of workers in the management of industries, this is been dealt through the Article 43A. Next, right to work, education and public assistance. This was this is given under Article 41 of the constitutions. And securing living wage and human conditions of work to worker. Now this option D is covered under two articles. The first, securing living age, is covered under Article 43 of the Constitution, and human conditions of work for worker is covered under Article 42 of the Constitutions. Now the question says that which of the given following principles of the DPSP added by the 42nd amendment to the constitution that added in 1976. So the A is there in the original, and C is also in the original, and D is also in the original. So answer is B, that is 43A. Article 43A was added by the 42nd Constitutional Amendment Act. Clear? Now if you see, so the DPSP Directive Principle of State Policy, that is part 4th of the Constitution, was amended 4 times in this till now. 4 times. The first was amended by the 42nd Constitutional Amendment Act, second through the 44th Constitutional Amendment Act, then 86th Constitutional Amendment Act has also bearing on the DPSP, and the last is 97th Constitutional Amendment Act. So these 4 amendments have an implication or effect on the DPSP. Now let's see through which amendment what changes was made in the part 4 of the constitutions. So here we can see that DPSP added by the amendments. So first was amended through the 42nd Amendment Act of 1976, added 4 new directive principles. So through 42nd, and this 42nd was the through this highest number of provisions were added, right? So through this it was 4 new directives principle. The first 39, that creation of opportunity for development of children was made changes into the Article 39. Then next, the new article added was Article 39A, which talks about equal justice and free legal aid to the poor, that the state responsibility to provide and free legal aid, that what we have discussed in the previous questions. The next Article 43A, that talks about participations of workers in the management of industries, and this is the options B is related to Article 43A. The next article added by the 42nd was 48A, and this talks about to protect and improve the environment and to safeguard forest and wildlife. So these are the 4 articles which has a change or added to the 42nd Constitutional Amendment Act. Now 44th Amendment Act has also made changes in the provisions. So it says that 44th Amendment Act of 1978 added 1 new directives, that is Article 38, which says that state to secure a social order for promotion of welfare of the people. Clear? Now next amendment was done in 86th Constitutional Amendment Act in 2000, changed the subject matter of Article 45, which says that provision for early childhood care and education to children below the age of 6 years. So this subject matter of 45 was changed through the 86th Constitutional Amendment Act. And the last amendment act was 97th Amendment Act of 2011, added a new directive principle, that is 43B, and it talks about a promotion of cooperative societies. So these are the four amendments through which the changes were made into the directive principles. Clear? Now moving to the next questions. So next question was also asked in 2017. So let's see the question. So it says that consider the following statements. With reference to the Constitution of India, the directive principle of state policies constitute limitations upon. So basically this question tries to convey that we need to find that part 4th of the Constitution put limitations on whom? Put limitations of whom? So if this is a core concept questions, if you have been cleared with the concept that directive principles part 4th of the Constitution is not a limitation, is not a limitations, rather it is a state right, either it is provide a state the rights, or we can say that it provides a guideline to the state, guideline to the state, that how the state should functions, right? So we can, in one sense we can say this is giving a right to the state to functions, that you can implement this, you can do this to provide a welfare state, to provide a fair state, right? So this is, so if you have been cleared with the concept, so by this term, that this key term, that it is imposing limitation upon what, so it is not there to put limitations. So the questions directly from here we can say that the questions ask that it is not putting limitations, so none of the answer would be options, that it is not putting legislation on legislative functions, it is guiding principle for parliament and state legislature, it is also not imposing legislative or executive functions, it providing them that you should work towards implementation of the laws that has been formulated by the parliament, right? So हम इस questions को to answer this questions what we can do, or through the logical limits, कि हम ये जो term है हमारा limitations, हम इसको ही base बना करके we can directly come to the answer that neither, because directive principle is not a limitations, it is a guiding principles act according to article 37 of the constitutions, which says that it has been a guiding principle, and the states are, the government are binding to the principles. क्लियर? सो ये किसी पर लिमिटेशन इम्पोज नहीं कर रहा है, ये गाइडिंग प्रिंसिपल है, एक तरीका ये गाइडलाइंस है ये. सो हम लिमिटेशंस को देखकर ही वी कैन डायरेक्टली कम टू द क्वेश्चन दैट इट इज नॉट बीन इम्पोजिंग लिमिटेशन ऑन एनीवन. क्लियर? So this can be answered without referring to the statement, just through the questions, through the nature of the questions. If we come and if we in a position to identify the keyword, that is, it is not a limitations on anyone in any sense, and because of this guiding principles, or because of this that it is providing a guidelines to the state, this sometimes this part 4 is known as a, because of this sometimes it is known as a positive right, because it is allowing the state, it is empowering the state to do something, to make the provisions for the welfare state. Is it clear? So if you see the directive principle of state policies enshrined in part 4 of the Indian Constitution, that is article 36 to 51, are guidelines for the states to frame laws and policies aimed to achieving socio-economic justice and promoting a welfare state. This has been stated under Article 37. We have already seen this. They are not limitations on legislative or executive function. Instead, they act as a guiding principle for the governance of the country. So, if you have been very clear in your concept about the directive principle कि ये पॉजिटिव राइट्स है, ये नेगेटिव राइट नहीं है. नाउ एज वी नो दैट पार्ट थर्ड ऑफ द कॉन्स्टिट्यूशंस आर समटाइम नोन एज अ नेगेटिव राइट. Negative right. Why it is a negative right? Because it restrict the action of government or state. It put limitations on the state. But unlike the part third, the part fourth is a positive right. It is not putting restrictions. Rather, it is allowing the state to do something to achieve the socio-economic or to promote a welfare state. So, as soon as you come to the term constitutional limitations, so it is without referring to the given statement upon which we can say it is not restricting anyone. Rather, it is giving power to them. So the answer to this is neither. Is it clear? Now moving to next questions. The next question was asked in 2015. Now the question says, consider the following statement regarding the directive principle of state policies. The first statement says the principle spells out the socio-economic democracy in the country. Yes, it is true. It is about the socio-economic country we have just seen. The second says the provisions contained in these principles are not enforceable in court. Yes, it is also true. This is we have seen under Article 37 of the Constitutions. So which of the statement given above is or are correct? So both of these statements are correct. So DPSP is about promoting socio-economic conditions, improving socio-economic democracy in country. Right? So DPSP aims to achieve socio-economic democracy by promoting ideals like reducing inequality, ensuring adequate livelihood, improving public health, providing free educations, and protecting environment. So through these mechanisms, the DPSP aims to achieve socio-economic democracy. Right? It will reduce the inequality by providing equal pay for equal work for men and women, ensuring adequate livelihood. That is a provisions under DPSP. It is also help the provisions to improve the public health, right? Providing free education, that talks under Article 45 of the Constitutions. So these are the mechanism through which the DPSP aims to achieve socio-economic. They are designed to complement the political democracy enshrined through fundamental rights, ensuring a balance between individual freedom and social welfare, right? So part third of the constitutions providing a political democracy, whereas part fourth providing a socio and economic democracy. And by combination of this, by combination of these two part third and part fourth, they provide a complete democracy in India or in country. Clear? Now, related to the second statement, we have already seen that Article 37 of the Constitution explicitly states that while the DPSP are fundamental in governance of the country, they are non-justiciable, meaning they cannot be enforced by the court. And we had already discussed the non-justiciable means the courts cannot interfere or the courts cannot give direction to the government related to any law, right? So both of these statements are true. Clear? Okay. Now let's move to the next question. Next question was asked in 2014. Now the question says, in the Constitution of India, promotion of international peace and security is included in, right? So does the preamble of constitutions promote international peace? No. Preamble of a constitution is only talking about four distinctions, or as we have already been discussed when we are discussing PYQs related to preamble, that it talks about only four directives that, or we can say that four dimensions. The first, source of power, source of power, that is people of India. Nature of state, that is sovereignty. Socialist, secular, democratic, and republic. And the third dimensions of the preamble or component of preamble, that talks about an objective of the constitutions, that is liberty, equality, justice, and fraternity. And the last dimension was the date of adoptions, that is on 26th November 1949. So, what I'm trying to say, that through preamble you can get an idea about these four components. That what are the sources of power, or what are the source to the constitution? The source of power to constitution, people of India. Which type of, what type of nature do the India have? It has a sovereign nature, socialist nature, secular nature, democratic nature, republican nature. What the constitution wants to achieve? The constitution want to achieve liberty, equality, justice, fraternity. And the date of adoption, that when the constitution was adopted, it was adopted on 26 November 1949. Other than these informations, none other informations can be gathered from the preamble. So related to promotion international peace, it cannot be from the, cannot be get from the preamble. So preamble cannot be our answer. Clear? So this cannot be our answer. Next, if we talk about the directive principle of state policies, so yes, according to Article 51 of the Constitution, that talks about a promotion of international peace and security. So B is our answer to this questions. For again, if you see the D, fundamental duties, Article 51A is a duty with related to citizens, and under this duty it is not and citizens are not through the 51A are bound to promote international peace and security. That is the duty of the state, right? So, and 9th schedule is related to the Land Act, as we all know in the terms of very general term. So this cannot be our answer, and this cannot be also our answer. So our answer is B to this questions. Now if you see Article 51 of the Constitution, so it talks about a promotion of international peace and security. So it says that states shall endeavors to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealing of organized peoples with one another, and encourage settlement of international disputes by arbitrations. So, related to international peace and security, it is a duty of the state which is provided under Article 51. So, answer to this question is B, that is directive principle of state policies. Clear? Now move to the next question. So next question was asked in 2013. So the question says, according to the Constitution of India, which of the following are fundamentals to the governance of the country? This is also a direct question. That is, fundamental of governance was mentioned in Article 37 of the Constitution. So we can say that the concept, this again a repeated concept, though the language has been changed. So we need to find that out of the following which isn't fundamental to the governance of the country. So do the fundamental rights is a governance of the country. It provides a governance. It provides an principles to country? No, it is related to individuals, right? And also it acts as an negative. So we can say it is an restrictions or limitations, imposing limitations on governance. It's not a fundamental. It is not a policy. So this cannot be our answer. Fundamental duties. No, this is related to citizens. It is not related to states. So by this also we can say this is cannot be answer. So if both of this cannot be answer, so our D cannot be also answer. So we are left with the directive principle of state policies. So according to Constitution of India, which one of the following are fundamental for governance? This is a directive principle of state policies. That is part 4th of the Constitution is a fundamental for governance of country, right? So this is answer. If we see the explanation, so according to Article 37 of the Constitution, part 4 shall not be enforceable by any court. This has already seen. The principles therein laid down are nevertheless fundamental in governance of the country. So whatever the principles laid down in under this part, that is under for the DPSP, and because of this fundamental, the part is known as a directive principles of state policy. So principles in a form of directives, in a form of guidelines to the state policies, how to state should features or should design their policy, that has been given under part 4. Because of this nature, this is known as a directives principles, right? So directives means guiding principles to the state policies. So this, as according to Article 37, has also explicitly mentions. It also says that it shall be the duty of the state to apply these principles in making laws. It makes that this part 4th is a mandatory on the terms of state to apply these policies in formulating a plan or formulating any schemes or law. Is it clear?